Check the mic and make sure it sound right.
Hi, I'm DK Will. It's DK Will Talk About It. And James K. Fallon has posted here that the Judge Torres issued an order on the party's motions to seal documents in the Ripple SEC case. And I'm no attorney, but I looked it up anyway, and what I read that stood out to me is it, of course, highlights the parties involved and says that the SEC had asked for some redactions, proposed redactions, protect the identities of expert witnesses, non-parties, and representatives. Garlinghouse and Larson also asked for redactions, and they asked for redactions in their behalf, in the behalf of their highly confidential business information, limited personal ID of defendants, legitimate privacy interests of third parties of which included MoneyGram, and then third party A, whoever that might be. But what stood out to me is the ruling, for the reasons stated below. The SEC's motions are granted in part and denied in part, whereas the defendant's motions are granted and the non-parties' motions are granted. So a full win for Ripple's request for redactions and a partial win for the SEC's request for redactions. All right, so now let's go find out what turned out to be what. As we take a look at the legal standard, I kind of liked it when I read this because the judge highlighted some important matters about the judicial system. The common law right of public access to judicial documents is firmly rooted in our nation's history. This presumption of access is based on the need for federal courts to have a measure of accountability and, key point, for the public to have confidence in the administration of justice. That's one heck of a start in my mind as a basis for rendering the judgments that were rendered. And it says, after finding that documents are judicial documents to which common law presumption of access attaches, courts must balance competing considerations against that presumption, quoting, of course, case files. The sealing of judicial documents may be justified only with specific on-the-record findings that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve that aim. And of course, the interest in favor of non-disclosure can include the danger of impairing law enforcement or judicial efficiency, something that the SEC kind of snubbed their nose at during this case. The privacy interests of those resisting disclosure, and concerns for witness safety. And although the protection of sensitive, confidential, and proprietary business information is a countervailing interest that can mitigate in favor of sealing, conclusory statements that documents contain confidential business information are insufficient to justify sealing. Rather, the moving party must make a particular and specific demonstration of fact showing that disclosure would result in injury sufficiently serious to warrant protection. All fancy words. I understand them. I'm not going to explain them. I am going to look here regarding the SEC's requests. It reads, the majority of the SEC's sealing and redaction requests are intended, quote, to protect the identities of its expert witnesses, close quote. The SEC also seeks redaction to prevent disclosure of personal information, including financial information of its experts, and to protect the identity of a non-party and its representatives. The SEC contends that one of its experts, open quotes, was subjected to extensive threats and harassment after that individual's name was publicly disclosed, close quotes. And redactions are necessary to serve the interests of witness safety. Okay. That doesn't make sense. because if the person was already subjected to that, there's no need to protect them anymore. But maybe they're talking about other experts. Therefore, the SEC proposes the redaction of expert names, contact information, educational employment history, publications, and affiliations. The SEC also requested the redaction of the names of consulting expert firms that assisted the experts and identities of those firms' employees. As to the proposed redaction of the experts' personal and financial information and the non-parties' information, the SEC argues that the redactions will protect significant privacy interests, and the presumption of access is lower for this information because it is not relevant to the adjudication of the DAUBERT motions. Okay. As a threshold matter, the documents the SEC seeks to seal are judicial documents because they are relevant to the court's decision on the DAUBERT motions. These documents include legal briefs, expert reports, and deposition transcripts filed in connection with the parties' DAUBERT motions, which may have the tendency to influence the court's decision on those motions. Because the documents were submitted in connection with a non-dispositive motion, they are subject to a lesser but still substantial presumption of public access. As the court has previously held, public dissemination of information about the SEC's experts, quote, may increase the likelihood of future threatening behavior implicating concerns of witness safety and the danger of impairing judicial efficiency, close quote. Here, the court finds that most of the SEC's proposed redactions are proper and necessary to preserve higher values, thus overcoming the substantial presumption of public access. It goes on to say, however, with respect to the names of the consulting firms that assisted the SEC's experts, I left that in earlier. I thought that would be interesting, but here we'll see what it says. The court finds that the SEC has not properly justified the redactions of this information, so they're not going to be able to hide. Who is it, Andreessen and Horowitz or something? The lawyer offices that helped Trump's competition in the previous election. The SEC has not explained how redacting the names of consulting firms would promote witness safety or judicial efficiency because the identity of each expert witness cannot be gleaned from this information. So they're not going to hide whoever it was, the firms that helped the SEC. Interesting. Now, it talks about the defendant's request, and we know they were granted. But let's finish this. It says, accordingly, the court denies the SEC's request to redact the names of the consulting firms that assisted its expert witnesses. There is no hiding. I think that's awesome. Of course, they granted the Ripple's request. And we're getting a long video here, but I'll just read them and get them over it real fast. Defendants seek redactions of 5 categories of information. 1. Ripple's non-public audited financial statements. 2. Confidential financial terms of Ripple's business relationships. 3. Identities of certain non-parties. 4. Identities of former and current Ripple employees. And 5. Personal identifying and financial information. Then it talks about their arguments in behalf of those requests. And accordingly, the court grants defendant's request to redact the documents submitted in connection with the DAUBERT motions. Okay, so going on. Accordingly, the court grants MoneyGram and third-party A's request to redact the documents submitted. Conclusion: the SEC's motions are granted in part and denied in part. The defendant's motions are granted. MoneyGram's motion is granted. And third-party A's motion is granted. That's a trifecta for Ripple. I'm DK Will. Let me finish that. Dated December 19, 2022 by Annalisa Torres, United States District Judge. And this is DK Will talking about it. I don't have much to say other than share this information. And I've talked about it. Have a wonderful day.
Check the mic and make sure it sound right.